My name is Dwayne Bensing, he, him pronouns. My role with the ACLU of Delaware is legal director. So happy to have folks join us this afternoon to talk about really what keeps us as a legal organization running, and that is our pro bono advocacy with our partners in private practice and those who are looking to help out. So thank you for your interest and thank you for your support of the ACLU of Delaware. As legal director, I'm often approached by folks in the legal field who say, how can I help in this time where folks are feeling like our civil rights are under attack and they want to do more and use their law degree to assist? Folks reach out and say, what can I do to help? And so the reason that we wanted to put together this panel this afternoon is to kind of answer that question specifically for attorneys. There are lots of opportunities with an integrated advocacy organization to chip in our organizing space, in our policy space. You can write letters to the editor, postcards, but as lawyers, we have a really specific, important role to provide public service in the public interest. And we have some folks who have really great experience. So I'm excited to introduce you all to them today to learn more about pro bono advocacy, some of the opportunities and making sure that you're living up to your ethical obligations as an attorney, and really what that relationship looks like, whether it's with the ACLU of Delaware or our other wonderful public interest organizations in the state of Delaware. So excited to start this conversation. I have two folks with me who are really phenomenal advocates who have done really a lot of work in Delaware, and just so proud to introduce them. And I'm so glad that they could join us this afternoon. I'll go ahead and start over with Jacquelyn Chacona. Jackie, go ahead and introduce yourself to the folks who joined us this afternoon.
I'm Jacquelyn Chacona. I'm the Deputy Director of Delaware Volunteer Legal Services. I've been with DVLS for 25 years. Started out as the domestic violence attorney, and throughout my time here, my role has changed. But the one thing that has remained constant is that I've worked with the clients and worked with pro bono attorneys, and that's always been the most important part of my job. So matching clients in need with attorneys who are willing to help has always been not only my primary focus, but also DVLS's primary focus. So of all the things that I do on a daily basis, every time that I get an attorney to say, yes, I'll help this person, that's the part of the day that is the best. The first question they wanted me to ask is what I think is the most important thing to know about pro bono work and ethical considerations. Even though you're not getting ethics credits for this today, I'm still going to throw out some rules just because I feel like I should. So there's the reason you should do things because the rules of ethics say you should, like 6.1, you should do pro bono. It's right in there. So that's the reason you should, according to the state and to the rules and everything. But the real reason you should is because it's the right thing to do. And honestly, even if you don't want to do it because it's the right thing, I don't care as long as you do it. I have a lot of different reasons people have told me that they're doing pro bono. The overall arching is people want to do good. They want to feel good about themselves. They want to put their law degree to use in a way that they find meaningful. All of that is fantastic. If that's your reasoning, I am all on board. But I'm all on board for the other reasons too, which includes a lot of attorneys. If you're working for a larger firm, you're not going to get your foot into the courtroom with your own case for years. You're going to second seat. You're going to do a lot of document review. You're going to do a lot of things that you have to do to get where you want to be, but you're not going to put your legal skills to use in the best way possible for a while. So I have some attorneys who just want to get the experience. They want to do a cross-examination. They want to do a direct. They want to feel what it's like to actually litigate. And I have other attorneys who don't ever want to litigate, but they want to work one-on-one with clients. So people who want to do transactional works like wills, powers of attorney, Miller's Trust, they still get that client relationship. There are a ton of other reasons to volunteer, because of personal experience, because of the way clients can change their lives, because you want to change clients' lives. But overall, I really don't care why you want to volunteer, as long as you do it.
Thanks, Jackie. I recall when I first started my legal career, I was at a private practice law firm in DC, and my very first opposition to a motion to dismiss oral argument in federal court was through a pro bono matter with that law firm. And so totally agree that you can really expand your opportunity to develop your legal career and your professional skills through taking on pro bono cases. I would say about 80% of the matters that we have filed at ACLU of Delaware are co-counseled with Delaware attorneys. And as a legal director who's supervising a lot of that work, I love to give junior associates an opportunity to get their first opportunity in a deposition, get their first opportunity drafting motions and getting that hearing practice and oral argument practice. So it's a really great opportunity to get some wonderful experience, and totally encourage folks, if that's what their motivation is, come on over, come join us and take on a pro bono case. So thanks for pointing that out, Jackie. I now want to invite our other guest, Joanna Cline, who has firsthand front row experience actually working with the ACLU of Delaware. Joanna's a great partner and really appreciate her joining us this afternoon. She's going to give us more of a perspective from those folks who are in private practice. Joanna.
Yeah, thanks, Dwayne. Happy to be here. So yeah, I am the managing partner of Troutman Pepper Locke's Delaware office, so a small office of a giant big law firm. So I've come at this with a little bit of a different perspective in that most of what I do is business litigation for corporate clients, but have always, since the beginning of my career, tried to carve out time to do pro bono work, including starting in about 2013, I think it is, with the ACLU of Delaware and my predecessors, even dating myself. So we got involved with the ACLU and CLE starting back, I think, around 2013, in connection with advocacy on behalf of prisoners with mental illness. Specifically folks in solitary confinement. And I'd imagine if you're struggling with mental illness and you're in solitary confinement, on top of that, things aren't going to go well. So we worked with the ACLU and CLE with ultimately a lawsuit against the state and then a settlement, which had a monitorship for a number of years that has now expired. And we're once again sort of partnering with the ACLU on some of those issues. So it's been a really successful partnership. I think sort of doing some good as well as getting some of the opportunities that Jackie and Dwayne have been talking about, and we'll get into a little bit more detail in that. But it's a win for all involved, really. In terms of what the most important thing to know about pro bono work and ethical considerations, I think I'd start with scope of engagement, and we can get into the weeds of this a little bit, but it's important for several reasons, whether it's paying clients or non-paying clients. And I think in both contexts, we as lawyers tend to forget about the mechanics of things like engagement letters and want to just jump into doing the work. But scope of engagement is important. Number one, because it defines expectations. Particularly if you're dealing with a client who may be a little bit more unsophisticated and not sort of used to retaining consultants to help. You want to make sure they understand what it is that you're doing and what you're not doing, so that everybody's on the same page. And if they want to do more than whatever is the scope of your engagement, they are from the outset understanding that and able to reach out and find some help from someone else if appropriate, or just basically know that that's not a service that you'll be providing. And that's in addition to just sort of setting expectations, it also becomes a risk management and liability issue from the law firm or the lawyer's perspective. You want to make sure, again, that if you're not let's take it out of pro bono for a second and talk about sort of just general business practices. You may be consulting with a client, on a particular issue. Let's say you're giving corporate structure advice. We have a specific carve out in our engagement letter that is specifies, but we're not going to give you tax advice unless you and we specifically agree, right? Because you don't want the client to come back later and say, well, wait a minute, there was this tax issue and you never told us, right? So in addition to setting expectations, let's be realistic in terms of reality, working to have a well-defined scope of engagement. protects you on a liability front. And then finally, the third reason why it's important is resources. We want to devote our resources to be zealous advocates for whatever the scope of the engagement is, but it can't be endless. And sometimes pro bono clients have a tendency to want to say, well, I need help with all of these things. There's so many things that they need help with, that they tend to say, well, can you also help with this? Now that we've built this relationship, I really need help with this issue over here. And it's really important, unless you have the capacity to kind of expand, that you bring it back to the defined terms and keep sort of eyes on the prize and focus on the mission. That's the point of the engagement.
That's a really great point, Joanna. Really, no good deed goes unpunished when you're an attorney. If you do a good job, your client's going to come back and ask you to keep helping represent them in all the ways in which lawyers can show up and assist folks. And so really great. And I know I can speak for myself here. It's always great to have a reason to be able to say no, because there's so much work out there to be done. There's so many fires that need to be put out and so many folks that need representation. Here at the ACLU of Delaware, a lot of folks think we're a direct client client services organization or law firm, and we're not. We are an impact litigation organization. So we're really looking for systemic issues and ways that attorneys can engage to make a broader impact. Sometimes folks in their individual capacities serve as a catalyst to help bring that large scale change. But generally, we're looking at organizations and other folks that are really attacking systems that undermine our fundamental civil rights. So, I think that's one of the learning curves as we're dealing with clients who are seeking our assistance, to make sure they understand what that scope of engagement is, not just organizationally, but also in that direct representation agreement. So that's a really great point. Thanks, Joanna. Jackie, can you go ahead and kick us off and share why, in your experience, you talked a little bit about this a moment ago, but why lawyers are seeking out pro bono work, and what impact it has on the folks who are served by Delaware Volunteer Legal Services?
So I went over some of the reasons why people volunteer. There's a couple more that I can throw in. Sometimes it's guilt. People they're feeling guilty about what they're doing in their regular job, so they want to throw some pro bono in. Again, I'm okay with that. One of my favorite reasons that people volunteer is that they discover they have more time. So we have a lot of retired attorneys who would volunteer for us. And I've been here a very long time, so I've seen the sort of life of a pro bono attorney. I didn't see it when I first started because I wasn't here long enough, but now I have. So there's a lot of young associates who, like I said before, they want to get that experience, so they are all in for a little while. But then if they're in a larger firm and they're sort of on the partner track and they have less time to give, the desire is still there, but the ability is, so the amount of time they can give sort of weans off a little bit. And then when they're partner, what I love about partners is that they can just tell people. They might not have time themselves to do it, but they can say, okay, I'm feeling guilty because I can't do this. You guys are going to do this for me. And then once people get into the later part of their career, or even when they retire completely, then they have more time. We have some attorneys, one of whom's a participant today, who once they started volunteering, they volunteered throughout their entire career. Now they're my go-to person for emergency cases for wills. I have other attorneys who they tell me, I'm going to be out of the country for 3 months, but in those 9 months that I'm here, I'll do whatever you want me to. So a lot of it is timing. So the desire is there for a lot of people, but the ability isn't. So I will take anybody in any stage of their career, whether they're first starting out, whether they're established and can't give as much time, or whether they want to donate a whole bunch of time. And going back a little bit to some of the ethical considerations, the one thing that has always been sort of the driving force is that when you get a client from DVLS or ACLU or OCA or any agency, that's a client. It's not a pro bono client, like in quotes, it's a client. So your duty to that client is the same as to the people who are paying you whatever your hourly rate is. The due diligence, the advocacy, the time that you put in, it's not something that you can do sort of half in, half out. It's your obligation, your ethical, moral, legal obligation is the same, no matter if it's pro bono or not. And I should have touched on that earlier. And the other thing that I could talk about, the impact that, not only the impact that the attorneys have on the clients, but the impact that I've seen the clients have on the attorneys. It's not a one-way street. Now, not every client that you take from DVLS or ACLU or any other, you're not going to love them all. I can promise you that, because they're regular people. But even if you don't love them, you probably will love what you do for them and the experience you get out of it. So the impact on the clients can be life-changing. I don't want to oversell it. You're not going to change every client's life, but you are going to change some. A lot of the clients that we work with are victims of domestic violence. So I've seen clients who are helped for maybe the first time in their lives. They're removed from a situation that was holding them down, was terrorized them literally and figuratively, and they got a fresh start. Away from an abuser, I've seen people thrive, start new careers, start new lives, and it's generational. Unfortunately, not everybody who comes to us is a success story. Some people go back to their abusers. And again, I've been here a long time, so now I'm seeing their kids come because it's the same sort of pattern. But we keep trying, and we have more successes than we have failures. And I don't consider it a complete failure. It's just a failure for now, because we'll help them later. And then we also help people with housing matters. So literally you're saving people from being on the street. If you can prevent an eviction even for a short period of time, an eviction is sort of like the first step off a cliff, because once you lose your housing, you lose a lot of things after that. You lose your kids, you lose your job because you don't have a place to shower and to get ready for your day. It's just sort of the first step. So some types of cases that might not seem that meaningful or impactful absolutely are. Including cases like estate planning. What's the big deal if you have a will or not? It is a big deal, because especially with an advanced care directive, a power of attorney, having the ability to make decisions about yourself, having the autonomy to say, this is what I want, and you guys have to do this, is amazing for people. And also, it gives them peace of mind, and that can never be overstated. I have helped so many elderly people who got a will, and they're like, when we're wrapping everything up, they're like, great, not everybody's going to like this, but they're going to be mad at me and not each other. So they're trying to save a generation of fights by doing these documents. But I've also seen it impact attorneys. When an attorney can have a successful result and they can see that a child is no longer being abused, that someone has a safe place to live, it affects them on a personal level. And we have had attorneys who have sort of changed the entire course of their career because they didn't think they were litigators until they took a case and litigated. And they literally changed. They were in a huge firm. They changed from the transactional unit to the litigation unit. And it sort of changed the way they looked at everything. So these changes are not just for the clients. I think they're equally for the attorneys as well.
Thanks so much, Jackie. I was just looking back at, at the preamble of the lawyers' ethics rules. You were talking about the different ways in which lawyers show up for their clients. And, the preamble section 2 says, as a representative, we perform various functions as an advisor, as an advocate, as a negotiator, as an evaluator. And it sounds like all those roles are just as true in pro bono service as they are in your billed work, day-to-day work. Joanna, when I was at a law firm, the not so secret was that a lot of associates said that their favorite work was the pro bono work, and some of their great opportunities to do the practice of law, kind of the things that they applied to law school to do, in fact, were the things that maybe they weren't billing by the 6-minute increment on, but were the things that they were working with pro bono partners. So I was just hoping you might add any additional thoughts to what Jackie was discussing.
Yeah, I agree with all of that. And let me just sort of frame my response in a little bit in terms of the rules of professional conduct, right? So there are different ways from a big law perspective or otherwise that people come to pro bono work. It could be voluntary pro bono work under Rule 6.1, which, as Jackie already mentioned, is like right there in the rule. You're supposed to do it. You could also be court appointed under Rule 6.2. And then there's sort of a hybrid to think about, which is in Delaware, for example, the federal court has a panel, which you can volunteer to have your firm or your practice put on a panel where you're sort of in the on deck circle waiting for a court appointment to come your way. So it's sort of voluntary, but you're in the panel, and then the court decides how you're going to be appointed. And so, obviously, a commitment to helping those who need help and can't afford it is sort of table stakes when you're talking about pro bono work. But from a big law perspective, it's really more about advocacy on behalf of your client than activism for a particular issue. And so the pro bono platform, to Dwayne's point, gives you the opportunity to do that in connection with professional development. And that is, not just give the opportunity for people to do good, but for them to sort of increase their skill sets, their experiences, and sort of build their resume. So in my firm, I sit on our Associates Development Committee. And I think a lot of firms nowadays have sort of formalized benchmarks for associates to help them in their professional development. When you're a first year, you should be familiar with, as a litigator, you should be familiar with, document requests and discovery and how that works. And then you progress to maybe you should be familiar with how to take a deposition or to prep for a deposition. Then as you get older, maybe it's more about experts. And again, I'm talking from a litigator's perspective, and then ultimately trial. And it's hard at any point in one's career to have a case that just so happens to have the experience that you're sort of building up to, that you're prepared for. They're not always available. So the number of conferences I've had with associates who's, we say, how can you help you? What are your goals in professional development? 9 out of 10 times the top on the list is I would love to get some trial experience. But in a big firm, that's not often available, and it's not very common. And enter pro bono, right? Another win-win situation. The pro bono cases on the federal panel, working with the ACLU and otherwise, provide lots of opportunities that a young lawyer might not get on a paying client matter. So my first jury trial was in a pro bono matter in Pennsylvania that had been assigned by the court. And then once you get that under your belt, when paying clients are looking to staff cases for trials, they want to know, do you have any trial experience? And pro bono is another way to help you to say, yes, as a matter of fact, I did. So again, from the professional development experience, it's being able, I had an associate literally 10 minutes before the CLE started come in and talk about how she would like an opportunity to do some depositions. And sure enough, we have, to Jackie's point, a retired partner who sort of partners with CLE and does some cases for them in which a bunch of depositions are coming up. So now we can couple the associate who wants to take deps with the retired partner who's working with CLE. And there you go. So we have a good professional development experience, and we're helping people, again, who wouldn't ordinarily be able to pay people to take depositions. So it's great. So we have those professional development skills, depositions, trial skills. Jackie talked about some of the things on a more corporate transactional side or a trust and estate planning side. And then there's sort of a catch-all category of learning how to deal with difficult situations. And learning how to deal with clients who are emotional, because paying clients can be emotional too. And it's good as counselors to have a little bit of this ability to help people through a difficult confrontational time in their lives, and try to learn how to set boundaries, yet be supportive and be that zealous advocate that the rules require us to be. So that was a long-winded answer to your question, Dwayne, but those are just a few additional thoughts.
No, I love that, Joanna. I was thinking back, my experience in the law firm when I was doing pro bono, and now the advice I give to junior associates, I tell them, you want to build your substantive knowledge, but you also want to build your social network. And so much of what I developed through my pro bono work was mentorship relationships with partners I otherwise would not have worked with, who served as reference letter writers later on, advocates outside of the law firm that I would have had no reason to associate with in my day-to-day work for my paying clients, but helped me build that professional network. And so that's just a really great other element of the benefits of doing pro bono work. Dwayne, I thought you might, hoped you might share a little bit about, you've worked with the ACLU, I think you said since 2013 or so. Well, this is an ACLU event, so I'll go ahead and plug us a little bit. What called you? How did you pick the ACLU to work with, and then any other pro bono that you've done? You've done a lot of pro bono with a lot of different for a lot of different folks. But what particularly about each of those projects or organizations? What led you to kind of choose which projects you take and which projects you don't take?
Start with the ACLU in particular, I'm not in your organization, so if I say something that's inaccurate, you'll have to correct me. But my outsider looking in impression is that y'all have sort of this policy piece, coupled with an advocacy piece. So from the perspective of outside lawyers who may not have their finger on the pulse of what's sort of going on in the legislature or the most current events in the prison system or in the immigration system or whatever the case may be, we may not be able to sort of flag the issues that are kind of hot and are in need of attention, but the ACLU does all of that. So you all have this panoply of different issues and ideas and things that you would like to accomplish, and you're sort of in need of a deep bench, as I understand it, to help you sort of carry those balls forward. So from our perspective, we have associates who are looking to do work, and then we need to sort of assign the workforces to a cause. And so in my experience, that's the case with the solitary confinement and the prisoners with mental illness. That was all the ACLU and CLE. It's a little bit complicated because CLE has a statutory mandate to help folks with mental illness. But the ACLU and CLE were very aware of these issues and sort of very knowledgeable about what was going on. And then we're looking for a partner in terms of outside counsel to help kind of just staff it up and just bring the resources to the table to help kind of advance the lawsuit and the negotiations and so forth. So I think it's in a law firm, you have a lot of people who have good intentions, want to help folks who need resources, but maybe not a whole lot of structure in terms of ideas and so forth. And so if you couple the need to want to do good, or if you couple the desire to do good with the pre-existing framework of the ACLU and other legal services organizations, it can help sort of be a symbiotic relationship.
Well, we certainly couldn't do the work that we've done without your assistance. And firsthand, one of our first Zoom meetings on one of the projects we've worked together with, having the Troutman folks show up on a Zoom meeting, and you all roll deep, and I'm like, oh, I have the backing now. You'll have more folks assigned on a pro bono project than I have hired in my entire legal department. And so it really does. It is a symbiotic relationship from my perspective, and so valuable. And thanks, Joanna, for talking about, what interests you about working with the ACLU on pro bono matters. For those of you attending who want to work with us, you know how to find me. I've always got something for folks to work on. Jackie, you talked a little bit about kind of the particulars that DVLS attorneys have worked on. You mentioned some housing cases, domestic violence matters. Can you say a little bit more about what particular opportunities there are for folks who maybe are looking for a kind of a discrete type project to work on in the volunteer pro bono sector?
Yeah, absolutely. So the availability is endless, and that it just never stops. So most of what I'm saying, if someone has the availability and the desire, there's going to be a case there. And what I sort of do, I do this when I do other types of presentations, is I like to tell people if it's litigation based, if that's your area of interest, the length of typical commitment, you can't guarantee, you can't hold me to it, but this is like, I try to say that typically this is how long you'll be involved in the case, and then give other options for non-litigation. So everything DVLS does is civil litigation. So there's no criminal. It's usually family court, justice of the peace court, chancery court. Not a lot of superior court work, but a little bit. I'll go over the family court. Everybody sort of cringes when they get family court. So here's the plug that I will do for family court. If you're an attorney in Delaware, at some point you're going to get a court appointment, and you're going to represent somebody in family court. It's better to sort of get your feet wet with us than just get thrown in by the family court. So there's my plug that it's coming for you, whether I give it to you or the court does. You're going to get it. And just the level of comfort, because our cases are not as intense as the court appointment. Well, they are. That was a complete lie. But they're happier cases. Okay, sort of. So we help victims of domestic violence with custody matters. That's full-on litigation. And in the time that I've been practicing for the past 20 plus years, family court work has been much more formalized than it was when I first started. So when I first started, there were no depositions. There was no discovery. You just sort of walked in the courtroom with your client, and that's all changed. So if you want to do depositions, if you want to do interrogatories, if you want to have a level of that type of litigation work, custody cases, especially if there's an attorney on their side, is much more formalized and does much more discovery than it ever has before. Those cases typically last 2 to 3 months, depending on when you get it. And the time commitment is spread out a lot over that. It's not a lot of intense work right away. You can spread that over if you get the case far enough advanced. So depending on the firm you're with, some firms, when I say, oh, this case will take 30 hours, the firm is going to take 90 to 100 hours, just because that's the way they practice. But a typical attorney for a custody case would be, 30 to 50 hours over a very long period of time. Protection from abuse matters are much shorter in duration. You put a whole bunch of time into it for a couple of days, because the turnaround time on those cases is only a few days. So you don't have a lot of time. There is no discovery. It's not a long drawn out process. So those, 3 to 6 hours, 1 to 2 days is the length of commitment to that. The other types of cases that we do that are litigation based are landlord-tenant cases in justice of the peace court. Currently, all of those are over Zoom. So if you have an interest in doing that, and a case comes up downstate, doesn't matter where you are, you can take it no matter what. We also do, back to family court, guardianships of minors in special juvenile immigration cases. So we have children who come here unaccompanied who need to get immigration status. And the first step to that is getting a family court order with magic language. Those cases, again, sort of like custody cases, longer period of time, the work spread out, so it's not intense all the time. And the landlord-tenant cases are typically like 5 to 10 hours of work. We do guardianships for adults in chancery court. Those I call quasi-litigation, because the cases we take are not contested. So we always find 2 attorneys, obviously from 2 different firms, one who represents the person seeking guardianship and one who is representing the person with the alleged disability. To be the attorney for the person with the alleged disability, you have to take the chancery court training. And that's more transactional. You are meeting with the person with the alleged disability, the doctors, and then you're writing a report. The person assisting the petitioner, the person seeking the guardianship, that's more litigation. You're filing a petition, you're representing that person. Typically, it's not going to be contested litigation, but you are going to get into the chancery court. You're going to meet and get your face before the different hearing officers. It's a great opportunity, especially if you do other types of chancery court work, because the court is overwhelmed with these types of cases. And I believe that they notice who's doing these cases on a pro bono basis, especially in chancery court with these types of cases. The hybrid, the strictly transactional cases would be the estate planning documents, your will, your power of attorney, your advanced healthcare directive. And then we also have people help with Miller Trust, which is a document that is created if someone is over income for Medicaid. It gets them, even if you're $11 over income, it doesn't matter, you're over income. So this helps people who otherwise couldn't afford things be able to get those benefits. We have a expungement program that one of our attorneys, Tom McDonough, he spearheads this, and we have again, a retired attorney, Jack Denny, I want to shout out to him. He is in our office and he just churns through these like you can't believe. But we help with discretionary expungements. And then there's a lot of other little things that we do. So, and I talk to people all the time about volunteering, and my goal is always to volunteer for me. But if you're not going to do that, volunteer for somebody. I don't want somebody to have a miserable experience doing something they hate just because I want them to volunteer for us. I want them to find something that they don't have to be passionate about it, but they have to at least be fulfilled. And if that's not with DVLS, if that's with the ACLU or Office of Child Advocate or the Federal Civil Panel, whatever it is, as long as they're doing something, that's my goal, to find something that fits for everybody.
So many opportunities with DVLS. Thanks, Jackie. And I should say, even with ACLU, you don't have to agree to take on a multi-year litigation like Joanna has. We have lots of investigation opportunities for folks to work with us, to do FOIA requests, review data, help us with some of our intake. We receive hundreds of intake each year. And so lots of opportunities for folks to utilize their legal training to help the ACLU of Delaware as well. I want to say, if there are questions coming to mind for anybody who's with us this afternoon, please drop them in the chat. Let us know. We'll hit those questions at the end of today's presentation, which we're quickly approaching. So go ahead and drop any questions you may have in the chat. Joanna, bring us to the very beginning in considering whether and what kind of pro bono case to take. What are some of the considerations, not only for you as a partner at a law firm, but as you're advising junior associates and they come to you with wanting to get involved with a pro bono case? What are the things that that an attorney who's thinking, oh, do I want to dip my toe into this or not? What are some of the important considerations before committing to pro bono work?
Yeah, some of the considerations are similar to the ones we talked about earlier in terms of professional development. I guess, the number one question is, what are you looking to get out of this? Like, we know that you're wanting to help someone. But other than that, or in addition to that, how can we help you find something that you're going to find personally and professionally meaningful? And so for some people, that means, I spend all day litigating, not I personally, but one might spend all day litigating pharmaceutical cases involving pharmaceutical products or medical devices. So I would like to, in my pro bono work, do something that has absolutely zero to do with that. So it's a good opportunity to get a diversity of either subject matter or industry into your practice. So maybe you do litigation, maybe you want to try helping someone with a will or something like that. So it's a little bit of a way to diversify. On the other hand, some people say, I'm a chancery court litigator. I would like to get an opportunity to be in the court more because it's just such a daunting experience sometimes. So to Jackie's point, maybe you take a pro bono case that's going to get you in chancery and get you a little more familiarity and appearing before some of the VCs and getting your toe in the door there. So I encourage folks to think about not only the things Jackie was talking about in terms of what are your time constraints, what's your window, your horizon of opportunity, but sort of substantively, does this interest you, and is this going to fulfill something for you, in addition to sort of just the general rules of professional conduct and the need to help those who are less fortunate than we. But what can we get out of it to make it the most productive experience for everybody involved? And I guess in terms of, and then bringing it back to sort of the risk management issues, we also have to think about, not how are we going to start it, but what's defining the goal. We talked about scope of engagement, also talk about the goal, and then how are we going to end the relationship? Because sometimes in a pro bono context, there aren't the same incentives and disincentives to continue with litigation when things are starting to resolve themselves or the issues before the court in a litigation. So in a paying client context, the client may say, hey, our case has been narrowed to X, it's worth so much money and it would cost so much money to continue to litigate it. Maybe that doesn't make sense economically, let's settle it. Whereas a pro bono client, sometimes we had a court appointment case for a prisoner where we were able to get some accommodations for the prisoner in terms of some assistance with eye surgery and things like that. And we sort of thought as counsel, maybe this is a time that we can settle the case because the prison has caved on a bunch of stuff. The client, of course, didn't want to, right? So we had a little bit of a situation where there were different goals, and we sort of needed to find an exit ramp, and so we needed to put guardrails around that. So there's got to be communication around what's the beginning, what's the goal, and then what's the ending. So again, not to be just sort of so practical, but in terms of big law or private firms, you've got to be careful about what you're committing to and making sure again we set expectations in the beginning. And then we're able to end the representation at some point, including with an end of representation letter that makes clear that things are coming to an end.
I really appreciate those practice points, Joanna. And when I was at a junior associate, my law firm had a pro bono counsel who kind of helped walk junior associates kind of through each of those steps and kind of helped us through the practical pieces. Do you have any pro tips for our junior associates of who are the folks that they should reach out to? Should they cold email Dwayne Bensing, legal director, or are there particular folks within law firms that folks should keep their eyes open for to reach out with to guide them?
Yeah, so it depends on your firm. If you're in a giant firm like ours, we have a director of pro bono who is a partner who has, I think, a staff of 4 other lawyers, because that's how big our firm is, which is great because they not only help you with the sort of the mechanics of the things we were just talking about, but also if you say, I've got a very particular interest in education law, or I want to help students with disabilities get their IEPs done or whatever, that Sarah and her team can help connect people with a particular, a particular interest. So if you've got a big firm that's got a resource like that, great. If you don't, if you're in another type of organization or a smaller organization, find a mentor, formally or otherwise, who might know people around town, or who can connect you with people like Jackie, with people like Dwayne, so that you can sort of not be out there on your own. Take advantage of people's contacts. People love it when you go ask them for advice. So don't go it alone. Get some counsel, whether it's inside your firm, take advantage of the bar association's networking. But there are plenty of people around who would like to connect you with others so that we can all sort of work together to help folks.
Thanks so much, Joanna. This is an ethics CLE, so we're going to talk a little bit about the ethics rules. And Jackie already warned us that she's done her homework on some of these ethics rules. Jackie, go ahead and get us started here and tell us, how does pro bono work align with our legal ethics requirements? And what are some of the particular rules that attorneys should be cognizant of as they engage in pro bono work? You're muted. Jackie, I think you're still muted. Sorry.
I'm sorry.
I got
didn't
you.
want
There you
to hear
go.
me shuffling my papers before. So I start out with 6.1. We've said it before, but I'll say it again because that's the one that I can hang my hat on that says, look, there's something that says you should do pro bono. Delaware is not a mandatory pro bono state. It is a highly encouraged pro bono state. But in addition to the rules, and I can go over like the other rules, like when you're representing the client, rule 1.3, your due diligence. In the preamble, it also talks about working with the clients and your obligation to, and I'll talk about this in a little bit, to be competent to do the representation. But the other thing is, a lot of firms, not as much recently as before, and I think that they're starting to get back into it, encourage pro bono work and allow a certain number of hours of their billable time to be counted as pro bono. So there are some firms that the ABA, last I checked, 50 hours is what they recommended. I hope that they're going to increase that, but some firms will allow you to take 50 hours and count that towards your billable hours, which is huge if you're in a large firm and you're in crunch mode every week. Other firms have a more liberal policy. They're not like, you have to do, once you get 50 hours, you can't do any more. And to Joanna's point, I also say, if you want to do pro bono, look in your firm to see who else is doing it. Even if it's a smaller firm and they don't have the pro bono, like firmly established hierarchy, if somebody's doing it, they can let you know how to do it. And sort of more pragmatic. When somebody comes to me and they take a case, we always give them our sample retainer, our sample forms, but a lot of firms want their own. So ours are there if they want them, but they should check with their firm to see if it, because there is one firm that is very specific, and they took our retainer and they said, okay, we'll use this, but we're changing it. I don't care if you use our retainer as long as you use a retainer. So you want to check within your internal policy what is required. Because you don't want to reinvent everything. I want you to spend your time working with a client, not trying to figure out the logistics of how to do it. It's already been done, hopefully, by somebody in your firm, and you should utilize those resources. And I don't know if you want me to jump ahead. This is sort of one of the later questions about competency. I have a lot to say about that, but I can wait if you'd want me to.
Well, let me just, I want to follow up on your retainer and co-counseling agreement thing. When I first became legal director, I spent a lot of time developing my model co-counsel agreement and retainer agreements. And I'll tell you, in almost every case, they've been edited at least slightly, because each firm definitely has the particularities that they want. And sometimes we throw it out and start all over again. So I think, Jackie, that's just a really great pragmatic point to make about these agreements. Nobody's doing this for the first time ever, but it's definitely a good thing to put some foresight into before you engage with a pro bono client and with the pro bono organization. But yeah, let's go into the question about competency. I think one of the main obstacles for folks or challenges that holds them back from engaging in pro bono work is this thought: do I meet the minimum competency levels that are required of me as an attorney to be a pro bono attorney for a particular client? So Jackie, you're ready to go on that one. So give us more.
I'm ready to go on that one, because I like that you said minimal, because you just need the minimal competency. You don't have to be an expert in whatever subject matter you're taking a pro bono case on. And DVLS, and I'm sure ACLU and the other agencies have systems set up to help you. So we have mentor attorneys. We have people who, if you're taking a case for the first time, you can either be the lead or the second seat, and then the next time you can do it on your own. It all depends on what their comfort level is. We have CLE resources, either trainings or materials. If it's transactional stuff, we have the forms already made up. And there's always a time when somebody's going to come in and say, I don't know what I'm doing. And that's okay. You just have to learn what to do. You don't have to know the first day how to do everything. Your obligation is to educate yourself and learn so that you can competently represent. A lot of people, especially two words that I think scare 98% of the attorneys in the state of Delaware, probably across the country, is family court. Nobody wants to go to family court, ever. But I'm telling you, they're coming for you. So you might want to try it out. These court appointments are no joke. You don't have to be an expert in family court. The law is digestible. It's something that you can pick up on pretty easily. And we have so many great family law practitioners that will mentor you, will answer your call, answer your email. So you can get up to speed on all of these cases. A lot of the cases, the law isn't super complex. It's just, and I remember when I first started practicing, there was nobody to tell me what to do or how to do it. And we have that. What motions to file, how to even physically walk into the courtroom, and because family court is still a physical file, where to go, what to do, where to sit, all of those things. If you've never done a trial, if you've never represented a client in a private setting, all of those things are fantastic learning experiences for attorneys. And a lot of people are hesitant because they've never done it, but that doesn't mean you're not competent to do it. And the one thing that I point out in a lot of the trainings is, if you've never set foot in a courtroom, if you've never litigated a case, the fact that you went to law school makes you so much more of an asset to the person who might not have even graduated high school, sitting next to you, looking to you for help. You have a level of expertise and training that the client you're helping could never reach. And you can do more for them just by even sitting with them and listening to them and giving them the confidence to move forward, even if your, knees are shaking, your palms are sweaty, that's okay. The more you do it, the better you get. And it's going to benefit not just our community of people in need, but it's going to benefit you for your practice throughout your career.
That's exactly right, Jackie. I have a first year fellow who loves to remind me, well, I've never done that before when I give him assignments. The secret that I don't tell him is that half the time I've never done it before either, but there's always a first time for everything. And I think these are really great opportunities. Joanna, can you say more about how you encourage folks to get over the mental block of, oh, am I competent enough to do pro bono work?
Yeah, it's, I guess, there are plenty of people who are doing things for paying work who it's their first time and they don't know what they're doing either, right? So there can just be terrifying experiences as you're starting your career or as you're starting a new practice area. So I think it's pretty common. But to Jackie's point, right in the rules and the comments to Rule 1.1, the comments say things like the following: a lawyer need not necessarily have special training or prior experience to handle legal problems of a type with which the lawyer is unfamiliar. Here's another comment. A lawyer may accept representation where the requisite level of competence can be achieved by reasonable preparation. This applies as well to a lawyer who is appointed as counsel for an unrepresented person. So basically, the ethics gurus have your back, right? They already have sort of anticipated this issue, and it's right there in the rules of professional conduct. We get it. There's no way we're ever going to have enough experts in family law to come in and do all the PFA cases and the guardianship cases, et cetera, that need to be done. So I think it's just sort of just kind of suck it up is my advice. To Jackie's point, I can attest that there are court appointments out there that will come your way. We just had an associate who was appointed by the court in a difficult guardianship case, and I think she logged over 300 hours to the case, and just super difficult. So yeah, she got to do a lot of arguments and things like that. So that was good from a professional development perspective, but obviously personally, it was just kind of difficult to deal with some of the issues, and we ultimately had to ask the court for leave to withdraw. So again, it's important to remember how do we work to end the relationship where that's appropriate. But the court is sort of forgiving, and the court appreciates your work as either a pro bono counsel or an appointed counsel. So I think the court will work with you if you get into a jam. But there's, everybody understands that you're, not an expert in whatever the field is, and so that shouldn't be a barrier at all, basically. And in terms of big firms and their policies about, whether pro bono hours count, like Troutman's policy, I think, is that 200 hours count. So we do try to dangle some carrots there to get the associates who are already working pretty hard to roll up their sleeves and do it.
Another obstacle that I often hear, especially in our work with the ACLU, where we're suing state and municipal governments, is the conflicts issue. A lot of our law firms, especially those in Delaware, represent state agencies or represent municipalities throughout Delaware. And so there's a conflicts issue that has to be worked out or sometimes can't be avoided. Joanna, can you talk more about, from the firm's side, that conflicts check process, how broadly firms approach that issue, and how, the consideration there for pro bono work?
Yeah, so there are both conflicts in terms of, whether we represent the state, so we can't sue the state, and there are also sometimes can be subject matter conflicts and positional conflicts. And particularly in today's climate, big firms need to be aware of all of those things. So I guess pointer number one is, whatever your workplace's conflict checking mechanism is, make sure you know about it, and make sure you remember that pro bono is not immune from those requirements. So the first thing you should do before agreeing to take on any pro bono work is talk to whoever's in charge of conflicts, or fill out whatever electronic form there is to make sure you're in good shape there. But you don't want to get yourself into a pickle by agreeing to do something where the firm has a positional or a substantive conflict. If you don't have a sophisticated or it sort of institutional conflict checking mechanism, again, it's always good to have a mentor to just kind of run things by and make sure you're not acting alone. Don't go it alone, no matter what you do. Talk to people, or if there's no one in your own organization who might know the answer to that, folks in these agencies, the Dwaynes and Jackies of the world, will be knowledgeable about these problems and can help you kind of navigate that and connect you with people to figure it out. And generally speaking, some kind of like, if you, particularly given this, if you work for a big firm, there are going to be conflict situations. In some instances, those can be waived consistent with the rules of professional conduct. Depends on what the case is, depends on what you're doing. But my experience has been that governmental organizations realize that there's a lot of work out there. They realize that there's a lot of pro bono work that is adverse to them. And they tend to be agreeable to some of those representations and will sign waivers even if the firm is currently representing them. So it's really just kind of a case-by-case situation. But you've got to run the traps on those things. You can't just blindly go in and sue somebody before thinking about those things.
Thanks, Joanna. And Jackie, you might have more information about this. I think that DSBA runs like a non-representational clinic for folks who are conflicted out from taking an actual case, can provide ad hoc legal advice on a short-term limited basis. Jackie, do you know any more about that? I'm a little over my skis.
Yeah, absolutely.
Great.
So it is, I don't know about how the DSBA, if they have a whole panel. I know of one program. And again, scary words, family court. It is, there are, a lot of times it's retired attorneys, and what they do is they give basically 15-minute blocks of free consultation, free assistance filling out forms. It's done right in the law library in the Newcastle County Courthouse. I think it's Mondays, 11 to 1 or 2, and people sign up in advance. So there are a couple of attorneys that are always there every week just to sort of help out. It's not a lot of time, but a lot of times it's enough for people to know, okay, this is my next step. It's not full representation, but it's extremely helpful. And my understanding, and I don't know the rule, but I know that conflicts don't attach to that because it is brief services. So it's sort of the unbundling phase that we went through a long time ago. This has been unbundled to the point where you're just giving brief services and there's no conflict checks. There's no record of anything. So that's very limited, but it's extremely useful.
Great. Some opportunities for folks who can't find their way out of a conflict. There's still opportunities even for those folks to help out. I wouldn't want to leave without us just underscoring one point, but the duties owed to a pro bono client, do they differ from an attorney's duty to paying clients?
So we have like a minute left, so I can say no, not at all. Nope, exact same duty. And in my opinion, maybe a little bit heightened. Like these people are vulnerable. So you don't have a different legal or duty, but I think you have a little bit higher of a moral duty to sort of, hold their hand a little bit more. I don't think your corporate dude that you're, is paying you out the wazoo needs you to hold his hand, but maybe your clients do. Just a little bit. You don't have to be there everything, just be kind.
Yeah, absolutely. And pro bono work is kindness. So thank you all so much for attending today's panel. I hope that we've encouraged you to take on pro bono matters, whether that be with the ACLU or DVLS or some other legal service provider in the state of Delaware. There's so much legal work that needs to be done in the state. Our clients need you, and so please step up to the plate. Joanna, Jackie, thanks so much for joining this afternoon. It's been a pleasure to chat, and until next time, thanks, folks.
Thanks so much.